Edwin, we just went live, so
All
I
right.
appreciate you on. We'll talk a little bit about your background and what you tend to do, but yeah, we did a post a little earlier today in the Creative Real Estate Investing group regarding judgments. I have a friend of mine that is going through a lawsuit. He had a situation where he purchased a property, fixed the property, flipped it, only went to the property once, and come to find out there were some flood issues. And he sold the property, didn't make much money, on it. And I think he made like almost $20,000. And now he's getting sued for roughly about $130,000, and he's got a judgment. So he's trying to figure out, what happens if he lets that judgment goes through, and the best way of going about it. But Edwin, why don't you talk a little bit about yourself, your full name, your background? I don't want to even try to pronounce your last name. I may mess it all up there. How you doing, man?
It's not that complicated. It's Edwin Epperson with double P. See, I've been doing private lending since 2014. I actually, for those in the audience or those watching may not have heard of me or know my story, I was actually in the military. I was a Green Beret with the 7th Special Forces Group, and I made my first loan on the side of a mountain in Afghanistan. And that was in the summer of 2014. Came back and I just fell in love with the idea of investing in real estate passively and not having to be geographically restricted or have to be in the area that I'm lending at. So in 2015, launched my company and have been doing that ever since. Of course, gone with the flows and different things have come up, and I've, dabbled in a few different other businesses, actually one that I'm getting ready to launch tonight. So I love private lending. I love helping investors be able to build their generational wealth, build their portfolio. And of course, much of that is through buying distressed properties like your friend did, fixing them up and either selling them to liquidate and provide more operational capital or to refinance into a 30-year. And I think that that's really the comment that was made on the Facebook group really revolved around what type of effect will this have in the long term for this borrower. And so that's a little bit, at least on my background and what I do. I operate throughout the state of Florida for fix and flip and bridge loans for 30-year rentals. I'm not lending out my money. I'm actually lending out or brokering for a large institutional investor for 30 years. So I can speak with some experience on the 30-year, and I know what those type of investors are looking for. When I say investor, I'm talking about the lender that's purchasing the note or providing the note. So that's really where that conversation stemmed out of, Mark, was when you commented that. And I said, well, if you start looking into that, his goal, his exit strategy for that property, which all of the investors that are watching this, that should always be, when you step into looking at a deal, you should have your end goal in mind. You should know exactly what your exit strategy is. And with this case, he is looking at the long term. What are the effects on like this judgment? What's it going to do for me or do against me in the long term? And I think that's wise. I hurt for him. It's a bad position to be in that position. And that's the exact scenario that everybody is like, oh man, that's what I don't want. But you're in the real estate investment space and you don't know whether you're going to buy a house with a sinkhole issue. You don't know if you're going to buy a house with, foundation issues that weren't disclosed. And sooner or later, I would estimate, if you're in the real estate business long enough, you will come across a scenario that is going to make you scratch your head and wonder, how in the world did I get in this? And so this scenario, while it sounds, really bad, and bless the guy's heart, I'm sure he's got some stressful nights right now, but these are the scenarios that we need to be prepared for as real estate investors.
Yep. And that's why I'm glad you jumped on and kind of explained from, a lender's point of view. Like, so let's talk about that a little bit. Like, how is that going to affect him if he doesn't satisfy it and he tries to move forward with a judgment against him? $130,000 it's a big, it's a big one to swallow, So how is that looked at in your world of how you guys look at when you're underwriting a loan?
So I would say, to caveat this, that it's so important to know how he owned the property. I'm assuming because he's a real estate investor, he probably owned it with his entity. So, and I'm not an attorney, and I will say right off the bat, I do not speak from a position of authority as far as the whole judgment process and the after effects and like what you can do or cannot do. as far as a real estate investor. But I do know this, that based on how he owned the property could affect in what format or which entity. And when I say entity, it could be a natural person or a business, which entity that judgment is attached to. If they're going after him personally, and he had a private loan and the loan was to his entity, that might be grounds for him to fight that, because technically he personally never owned that property. And that's one of the reasons why we have entities. That's one of the reasons why we as lenders, I refuse to loan to somebody who's going to buy a property in their personal name, even if it is for business purposes and they have their own residence somewhere else. I mean, everything else checks the block, but they're not using an entity. For me, that right off the bat is a sign of an unsophisticated real estate investor, because they're going to open themselves up to liability, in this case, being attached to the personal name. So that would be my first question, because I don't know how he owned the property, and that might give him grounds to fight, in which case he might want to pursue fighting this, because if he didn't own it in his personal name, legally, nothing can get attached to his personal name, which would be a huge benefit, right? So let's go to the other side of the coin. Well, what if he did own it in his personal name, or he just throws up his hands and is like, it's not worth it to fight it because it's going to be a lot of money to fight it. You're going to have to hire an attorney, go through the whole process, right? It's going to get wrapped up in litigation. So maybe he just throws his hands up. He's like, you know what? I'll just deal with it. I'll make the money and pay it off. That might be a consideration he's taking. Well, if that's the case and it gets attached to his personal name, this is the ramifications that will have on him personally, especially seeking leverage. When he goes to find leverage for another property, two ways that a lot of real estate investors are going about doing this. They're either seeking private money. When I mean private money, I'm not talking about private lenders. So private money is somebody that's very wealthy. They're just sitting on a boatload of money and they're willing to, loan it to you personally, but they're not running a business. They're not in the business or the profession of making loans. It truly is a source of private funds. And many times it might be structured like a joint venture agreement. So that's private money. And ultimately, that's like the goose that laid the golden egg. That's what you get taught in all the gurus and seminars. Go find private money. The next step up is a private lender, which is what I would classify myself. I do loan my personal money out. I do loan a select group of capital partners money out. I do the processing, the underwriting, the servicing of the note. It's basically a turnkey solution for passive investors. However, it's more of a profession. I'm running a business. So there are certain checks and balances that I expect that a real estate investor may say, well, that's not really private money because you're asking for all this additional stuff. It's because I'm running a business. And then the final step up is a hard money lender or an institutional investor. And I equate both of those in the same category because of this one caveat. They are going to pull a credit score. If any of your real estate investors, or if you, Mark, talk to a lender, and I'm putting that in quotations, and somewhere in the process, the lender says, well, the rates, the terms of this loan, what we're going to loan has to be based on your credit score, or your credit score, like there's a minimum credit score requirement, or your credit score will dictate X, Y, and Z. If that is the case, then you are working with a source of capital that is institutional in nature. Meaning what that means is that whoever is loaning, who actually has the money, it's not the person you're talking with. The individual or the entity, let's say, that owns the money is actually accessing that money from the secondary market. And the secondary market is Wall Street. And so what they're doing is they're making a loan to you, but they're also making a loan to 15 other individuals. They're going to package those loans up, which we all know are mortgage-backed securities. They're going to sell that security to Wall Street. So when you're dealing with a hard money lender or any institutional investor or a private lender that requests a credit score, you are actually borrowing money from the institution of Wall Street. So in the case that this gentleman throws his hands up, or he did buy it in his personal name, and regardless, at the end of the day, this lien gets attached to his personal name, that will affect his credit score. It will affect his credit history, if you will. Maybe not so much as credit score, because a credit score is a record. It is basically proof of how creditworthy someone is. So if you get a judgment, it's not necessarily indicative that your score is going to plummet, though it could affect that. But what it will do is it will be on his credit report. So when you go to get a loan from an institution or a hard money lender or a private lender, and they require a credit report or a credit score, they're going to pull the whole report. When they get the report, they're going to see this judgment. If you're accessing capital that is structured this way, where they are requesting a credit score, most capital are not going to loan. There's typically a 1 or a 2 year benchmark, 1 year for foreclosures and 2 year of no bankruptcies. Now, it depends on the lender. And I saw a comment underneath your comment, a gentleman or a lady had mentioned, well, it's lender dependent. And they are correct. It is lender dependent, but almost unequivocally across the board, there is going to be a certain amount of years to where the judgment has to be released, or it has to have been, and I forget the legal term, satisfied, or it's finished, it's satisfied, it's pushed away. They're probably going to request, and I've seen it as minimum of 1 year. So where does that put him? Well, he has to find either private money, or he has to find a private lender like myself that is willing to extend him credit for longer than that period of time, so that he can then wait it out and then refinance with an institution after that judgment is fulfilled or paid off. And that's going to be the big question mark for him, right? He doesn't know how long it's going to take to pay this off. If it takes him a few months, well, from the day that it's paid off and it gets dismissed or satisfied, well, that's when the clock starts to count for 1 year or however many months or years it takes to get a loan. But if it takes him 5 years, that's 5 years, and then he still has to wait an additional 1 or 2 years just to get a loan. So that could be the potential ramifications for allowing a judgment to go ahead and just say, you know what, I'm not going to fight it because it's going to cost more money than I have right now. So I'll just take the judgment and then pay it off when I can. Well, now he's really limiting his leverage capabilities. And if he doesn't have a very deep Rolodex, for lack of a better word, if he doesn't have a very deep Rolodex of a lot of private lenders or private money to draw on, that's going to restrict his ability to get capital.
So, because if it's open, do you still have a timeline from when the judgment was filed, like a foreclosure or bankruptcy, or is it, if it's open, it's still like,
if it's open, then that's going to be pending, and I will tell you right now, no lender that is so no. And when I say lender, let's rephrase that. No broker who is brokering institutional money, i.e. the lender, no broker is going to even submit that loan, because they know that the institutional lender is not going to loan on that cap or on any property that he purchases, even if it's not his name now. So that's the disadvantage, right? If it gets to attach to him personally, well, now, no matter what entity he buys future assets in, he is still the personal guarantor for that entity. So therefore, him personally, any judgments, any liens, anything that attaches to him will now be transferred to any new properties, because he's personally guaranteed. Now, if he can find a lender that does not require a personal guarantee, and they are okay him signing as the manager of that entity that he's buying the property with, then yes, he could get money. The problem with that is you're not going to find institutional money like that. You're going to find hard money, which is going to be, 10% plus annual. And when you're looking at doing that for multiple years until you get this judgment satisfied, that can drastically affect your spread and what you're looking to make out of as a revenue and profit on that deal.
Got it. So in this case, then how long would it take? Like, say, for example, okay, this thing's going to cost me so much more money. I'm better off of just filing bankruptcy and putting that judgment into the bankruptcy. Once an individual files bankruptcy, how long of a time period do they usually have before they can kind of start getting your lending again?
So again, I'm not an attorney. I would highly recommend, if anybody's looking at that route, that's a great tool. It's actually it's a good tool for real estate investors to know that they have access to this, because in this scenario like this, where the gentleman is just like, I've really been royally screwed over, going the bankruptcy route. And I personally know that it's a hard pill to swallow to say, yeah, I'm going to file bankruptcy, because I don't know, in the back of my mind, it would be like, man, I've failed at something, right? But it's a tool in our toolkit. And again, if anybody is in that position, your friend especially, or anyone else, and you're looking at a way to get to use the law to your advantage, consult an attorney and find out what's the best route. But even in bankruptcy, there's multiple types of bankruptcy, but you have a chapter 7 and a chapter 13. If you're going to go into bankruptcy, you absolutely want to try to go to chapter 13 because that will wipe everything out, all liens. The problem with that is, as a real estate investor, that's going to wipe out everything that you have. So clearly, he's just trying to fight this one judgment. But if he goes into chapter 13, it puts every lender that he has on notice. He's going into chapter 13 as well. When you declare a bankruptcy, chapter 7 or 13, both are the most common. You actually have to have a plan before the court. Chapter 7, you have to have a plan before the court that states, this is what I owe. You're going to reach out, or the court's going to reach out, or the appointed attorney on behalf of negotiating everything. They're going to reach out to every single one of their settlers of that investor, and they're going to say, not settlers, creditors, and they're going to ask the creditor, hey, this borrower you have, they're going in chapter 7. You have a $200,000 lien against this property. What will you be willing to settle on this property? And so there has to be a plan developed that the borrower, the defendant, the person filing chapter 7 bankruptcy has to agree to pay it back. So chapter 7 bankruptcy is not a clean slate, everything's gone. That's a chapter 13. So it all depends on the type of bankruptcy he wants to file. Again, I would definitely talk to an attorney, but that time frame is going to be dependent. Like, how long is it going to be in bankruptcy? That's going to be dependent on the type of bankruptcy he's filing. And then afterwards, it really depends on the type of lender that he's going to be going for. Some banks, especially your smaller banks, your local banks, which are sort of, if you're going to go institutional route, the local bank is going to be your best route. They may have a 3 or 4 year hiatus. They say, hey, listen, we don't want to see any bankruptcies within the last 3 to 4 years. If you go more your national lender, then, a big bank, then you might be, at 2 years or 1 year. I know that my lender for 30-year loans, they want to see 2 years of no bankruptcy. So, there's a lot of what ifs. I would absolutely encourage him, like, if this is even not because this is an issue, he should be seeking out legal counsel. And if he can't afford legal counsel, then honestly, go the chapter 13 bankruptcy. I mean, that's a hard advice to give, and actually I'm not even going to give that advice. Ignore that. Go talk to an attorney.
I mean, and depending on how you have your assets protected, also, if you have a lot of that stuff in LLCs, and if you do file, and again, talk to an attorney because it's different in every places. But like in Florida, your homestead protection, so they can't touch your home. Yep. They can't touch your IRAs. You can't touch your 401k. The only thing they can really go after would be if you whatever cash you have in the bank, and if you have all your entities set up in LLCs, they can't touch that either because that's a whole separate situation. So exactly. Yeah, it is a good, and you can see a lot of these real estate investors, look at Trump, he's been down that path. He's filed it before under the entities
multiple times.
Yeah. So I knew a story back in the crash of this guy down at the Related Group. You're probably familiar with them down in Miami. But anyways, they're doing a high rise, and when everything collapsed, he borrowed like $700 million. He filed bankruptcy, and then he created another entity and went and bought it back under another LLC for about $300 million. Isn't that crazy?
That is crazy. That's the workarounds that, you get an attorney that's like, they can dig into that. And, let's be honest, there is nothing sacred in the United States when it comes to litigation. If somebody wants to go out, they will hire attorneys after attorneys to go after you and get whatever they can. So obviously be wise about that. Seek out a good legal advice, but that is the reason. Yeah.
But anyways, from your point of view, if somebody files the bankruptcy, it would be roughly about 2 years at grace season period
after the bankruptcy is discharged. Yes, and that's really going to be the key thing. Every bankruptcy is going to be different. How long to get that discharge? It's really up to the courts and up to the attorneys and the
I was talking to, and your stuff is more LLC. I was talking to somebody earlier today, and he does residential, and he was saying on the residential side, going and it might be another lender that they have in their back pocket, that long as it's not a federal state judgment, they are willing to still lend on it. but they're going to charge them a little bit of a, like a 5% hit, or I don't remember what it was, 5% payment or something like that. I'd
Yeah.
have to dig a little bit deeper. But again, everybody's kind of has the different ins and outs. But I wanted to kind of get your point, because a lot of the people in our groups, they're doing fix and flips, and it's just good kind of getting some information put out there. So that's great.
Yeah. Yeah,
Well,
absolutely, man.
so yeah, we'll kind of wrap it up. Let's talk a little bit about yourself, like what you do, or if anybody needs some hard money lending, what states you do business in, and so forth.
Yeah, absolutely. Thanks, Mark. And happy to do this anytime you got something you just want to chat on. I love doing this type of stuff. I love education. I think it's what makes the grease on the wheels of progress, right? So I lend only in the state of Florida. I'm lending, again, like I said, my personal capital and some select passive investors capital out on short-term loans. So those are 12 months or less, interest only, typically to the fix and flip crowd, or the crowd that is buying a property, stabilizing it to prepare it for a refinance. We also have a relationship with an institutional investor that is specific to real estate investors. So you can buy the property in your entity, you can refinance it into your entity, or you can keep it in the entity and refinance. We have a great BRRRR product, a buy, let's see if I can get all the R's right, a buy, rehab, rent, refinance, repeat. So that BRRRR, the strategy BRRRR, we actually have a loan product that I personally developed that allows us to help you maximize your refinance and not be a cash out, though you will be able to pull your cash out, but it's not seen as a cash out for the end investor. So what that means is that you get a better rate and you get access to more capital. So we've done that. Right now, where the market's at, fix and flip it's hard to find a good deal, especially with the margins that we were seeing, 3-4 years ago. And so we do have a 30-year product for long-term rentals and short-term rentals. So for those investors that are looking to get in the short-term rental space, like Airbnb, VRBO, we have a loan product for that. It's a 30-year fixed rate loan, and they are perfectly fine. And they will actually, the NOI, the operating expenses for that property, is actually based on the income that you would generate from the short-term rental, which that's always been a hurdle for the short-term rental crowd. Is when they go to a bank or financing, the bank is saying, well, this is what it rents out every month. And of course, we all know that short-term rentals, you take that monthly rental, you multiply it by 2 or 3 times, and that's actually what you're able to generate. But the banks aren't looking at that as far as the income. And that's always been a hurdle for investors that want to buy properties for short-term rentals. Well, our product actually does look at that income that you would generate on short-term rentals. So a really great product. Rates are great. Rates are the same as far as the long-term rentals. So we're looking at as low as 3.625 for a 30-year fixed rate loan. And it's in your entity. We do require personal guarantees. So of course that has to be considered. And there are minimum credit score requirements, but most of the investors that I talk to, they definitely meet those minimum requirements.
All right. I appreciate it. Thanks so much. And I'm sure we'll probably jump on some more Zooms and stuff at the last minute thing. So hopefully this helped some people out there today. And so thank you guys so much. Edwin, hold on one second.